One of your FRQs is going to be about a Supreme Court case. Absolutely, no question. One of these 13 cases that's in your packet is going to be the subject of one of your FRQs, okay? No question about that. It's going to be there. Okay, so what is that question going to look like? That's what I want to talk to you about. Okay. So first, they're going to give you a scenario, a factual scenario. They're going to describe some event, some happening, okay? And that event is going to be in some way similar to the facts in one of the cases that you have to note, one of the cases in the packet, okay? And then they're going to ask you these questions. They're going to say, look, first, A, identify the constitutional clause that was used by the Supreme Court in this case and in the case that you know from the packet, okay? So, for example, one of the cases that you have to know is called Tinker, because the two plaintiffs in the case were named Tinker. They were a brother and sister who decided they wanted to protest the Vietnam War. And the method they chose to do that was to wear black armbands to school. School didn't like that, and they got in trouble, and they sued. And the Supreme Court said, in Tinker, it doesn't matter if you don't actually say words. The First Amendment protects more kinds of speech than just words. It also protects symbolic speech. Okay? So even if your armband doesn't say anything, you are still communicating a message, right? And the First Amendment protects that message. Okay? So in the question, they might give you a factual scenario about, there was one, I think it probably was on the test, just before I taught the class. There was a kid who, at a school event, he was actually across the street. He wasn't on school property, I don't think. But he it was maybe even a religious school. It was some sort of, and what he did is he brought a sign and held the sign up, bong hits for Jesus. Yeah. And the school got mad at him. And he sued. Okay? And the Supreme Court did not side with him. There were reasons for that. We don't have to worry about it. But that's an example of how they might find a case that was similar. And they like to use current events to do this. Okay? So the next thing they're going to do is they're going to ask you either about how those two cases, the one that you have to know and the one they just described, how they're either similar or different. Okay? So the first one of the options is difference. Based on the constitutional clause that you identified in Part A, explain why the facts and the decision of the Supreme Court case that you know, Tinker, in this case, the example I gave you, was different than the decision reached in the case in the scenario. Okay? Why does the Supreme Court make a different decision this time? To do that, to answer that question, you have to know what the facts are. You have to compare the facts and say why the facts in the first case led to conclusion A, but the facts in the second case, even though they are similar, led to conclusion B. You understand the logic that you're being asked to perform? Okay? The second possibility for Part B is that they ask you about how they're similar. Explain how the facts of each case led to a similar holding in both cases. In other words, why did the legal principle that led to conclusion A in the first case also lead to conclusion A in the second case with a different set of facts? Now then they're going to tack something else onto that. And it's probably not going to be about civil rights, or it's going to be about something else from the course. They really like to give you FRQs that are mixed, not just on one unit, but on all of them. So one question they might ask you is to describe the judicial consequences of the decision reached in the scenario case. Okay, so what does it mean? What difference does it make? Okay. right. Okay, so what difference does it make? What are the judicial consequences? The court is making law, for example, could be something that you said. The second possibility is to describe an action that Congress could take to respond to the court decision if it disagreed with it. If it disagreed with the decision in the scenario, what could Congress do about it? We already know some options. What can Congress do? What could Congress do if it doesn't like a Supreme Court decision? It can change the law. It can try to change if the law had a defect that can be changed, it can do that. What else can we do?
Ignore it.
Yes, although that's usually the president's job, because the president's job is to enforce the law, right? And one of the options for this question could be simply to replace Congress with president, describe an action the president can take if he disagreed with the decision. Okay? Another possibility, give an example of how a special interest group reacted to the decision. Now, this is more of a history question. I don't actually think the College Board would ask it this way. This came from another book. I think what the College Board would say is give an example of how a special interest group might react to the decision. That lets you pick an interest group. You pick the ACLU, okay, with regard to the Tinker decision on free speech. Because we know how the ACLU feels about free speech, right? You guys all remember who the ACLU is? American Civil Liberties Union? Okay. They're the free speech royalty. Okay, so you could get another question asking about media. What could the media do to, how could the media communicate the message about the decision? And what effect might that have on the populace? Okay, there are all sorts of things they could do to ask you how some government player might react. Okay. That's not what I want either. Now we're going to start talking about civil rights and civil liberties. Number 2 on my agenda. Okay? And the first thing we need to do is understand that there's a difference between civil liberties and civil rights. To me, it's kind of a difference without meaning, but there's still a difference. Okay, civil liberties. Civil liberties are those freedoms, freedoms, that are protected by the Bill of Rights. Okay, freedom of speech, freedom of religion, those things, right? Civil rights, those are the protections you have from discrimination. Okay, protecting you from discrimination based on race or gender or all those kinds of things. Okay. Everybody understand that? Now, I've started this out with some things that the College Board tells you that they want to know. They want you to know, and it's useful because there's a theme, a couple of themes in here that you need to remember about civil rights or civil liberties. Okay, first of all, as the College Board says, the Supreme Court's interpretation of the U.S. Constitution is influenced by the composition of the court and citizen-state interactions. Okay, so it matters who is on court, as we will know right now. The courts have become much more conservative since the advent of Donald Trump's presidency. Okay? But another thing that affects the court, which people have mixed feelings about, people like to think the court is independent of what the people think. They always decide based on the law. But the court pays attention to what's going on out in the world. Okay? And for example, if the court hadn't been paying attention to what was going on with regard to gay rights, we never would have gotten the decision allowing gay marriage in every state. Okay? So they see what's going on. It matters. Also, at times the court has restricted minority rights and at other times protected them. So the court has been very waffly. You know that word, waffling? Going back and forth. Okay. So, especially early in its history, it did not protect minority rights. But later on, it has generally done better. So, for example, there are there are some examples that we can talk about. First of all, as you guys learned in history, there were state laws, including, for example, the Jim Crow laws, but laws outside the South as well, and Supreme Court holdings that restricted African Americans from access to the same restaurants and hotels and swimming pools and as opposed to the majority white population. And we know that as the separate but equal doctrine. What case established the separate but equal doctrine?
I know it, but I can't.
Oh, it was Ferguson.
Plessy versus Ferguson.
Yeah. Okay, I was
Plessy
like,
versus 1898. Okay? Same year as the Spanish-American War. I think it was 1898. But then, later on, we get a reversal of that policy. We get Brown versus Board of Education in 1954, right? Which says that school segregation is but. Then we have other cases. This is, I don't think you're actually going to have to know very much about this, but I'm going to explain it to you. You remember when we talked about districting, apportioning, and I gave you that little map and I said, you've got 60% grays and 40% whites. You need to divide all these up so that you get all grays, all gray majorities in the five different districts, right? Okay. Then I asked you to divide them up so that you've got at least 2 districts that were majority minority. In other words, those districts had a minority of the white group, which was originally the minority, right? That's what's called a majority minority district, where you have a minority who's in the majority in the district. Okay? And they use that sometimes to help protect their voting rights. Because otherwise, you get a gray dominant in all 5 districts. And you get no voice in the whites, in the gray-white scenario. Okay? So that's an example. And sometimes the courts say you can't do that, sometimes they say you can. And this is what you get when you get the common law. You also get, you have to realize that you've got judges on the court who don't agree with each other about what the law is on some things. They agree with regard to most of it, by far most of it. But when you get to the edges of the law, when you're doing new things, okay, they don't all agree about where we should be going. Right? So an example of that is affirmative action, helping the disadvantaged, basically, especially with regard to race. And some people say we should have a colorblind society. We shouldn't pay any attention to color whatsoever, not even to help people who have been disadvantaged in the past. Other people say it makes sense under the Constitution to help those who have been disadvantaged based on their race in the past. Okay, we have people on the court who have these different views right now. Okay, so now we're going to talk about the Bill of Rights. And that was just kind of an intro to all of this. And we're going to start, all we're going to do today is the Establishment Clause, which is a little piece of the First Amendment, right? But it's the very first phrase of the Bill of Rights. Now, what do you need to remember about the Bill of Rights? The College Board, and the stuff they want you to know and do, say at least 3 times that you need to understand that the Bill of Rights has been interpreted differently over time. Okay? It's not being interpreted the same way now that it was before. Okay? You with me? Okay. It has changed along with all the other kinds of law that we have. Now, some people think, let me tell you this first. Okay, so they want you to know specifically that there's a Bill of Rights, and that the Bill of Rights is designed to protect individual liberties, okay? It's designed to protect you as a person, not as a group, but as a person, okay? They also protect different kinds of things. They protect us as people. They protect our opinions. They protect property, okay? And again, the College Board says it's continuously interpreted by the courts. Now, remember we have originalists. Remember we talked in the judicial section about originalists who think the Constitution should be interpreted the same way that people understood it when it was drafted. And there are some people who say that the Bill of Rights should be interpreted the same way as they did when it was drafted. What do you think about that? Where would that leave us? With a bunch of straight white men. Everywhere. Worse than it is now, even.
They would multiply.
William Brennan had something to say. William Brennan is a liberal justice. He's one of the justices I told you about that flopped after he got on the court. He was originally a Republican and considered a conservative, and then he became a liberal, like a raving liberal. Okay, he was even against the death penalty.
Oh.
And but he reminded us that the Bill of Rights do not purport to create rights. What they do is acknowledge pre-existing rights. Remember that the founders of this country believed in John Locke. And what did John Locke think? We all had these natural rights, right? And all the Bill of Rights did was to say, yeah, we're saying there are these rights that you have as a person. Okay? Now, the Bill of Rights says, for example, in the First Amendment, Congress shall make no law. And for a very long time, the Bill of Rights was seen as not applying to the states. So the federal government couldn't infringe your right to free speech, but the states could, unless they had their own constitutional provision about that. Okay? Oh, by the way, there are cases in here, okay, but there are two types of cases. There are cases that are in red. Those are the cases you need to know and that are in the packet. The case names that are not in red, you do not have to know. Like I say, they used to have to know more cases than they do now, and so some of these are artifacts. And also, they're in there to help me. They're kind of like notes for me. Okay? But just because they're there doesn't mean you have to know them if they're in black. Right? So, then comes the 14th Amendment, Civil Rights Amendment, right? Civil War Amendment. And this 14th Amendment doesn't say Congress shall not. It says no state shall make or enforce any law that deprives you of due process or the equal protection under the law. Okay? Now, even though that seems pretty clear, that at least this amendment applies to the states, the Supreme Court didn't really apply it that way very much. They didn't allow very many people to rely on it to protect them. Later on, though, the Supreme Court changed its mind, basically. It did so gradually. It did this process gradually, and the process that I'm describing to you is called the incorporation doctrine. So what they did was they held that the 14th Amendment, okay, that its due process clause protections basically include the freedom of speech and include the freedom of religion and include the right to be freed from unreasonable searches and seizures. Those are natural rights, and the due process right includes that. The process is basically about fairness. Okay? So in Gidlow, which was the first case and one that you used to have to know, in 1925, they applied the 14th Amendment to the First Amendment speech and press freedoms to say that we are applying the First Amendment to the states under the 14th Amendment's due process clause. It's legal maneuvering.
Wait, can you say that one more time?
They decided that via the 14th Amendment due process clause, the First Amendment is applicable to the states.
Okay.
Okay? So now, federal law says a state can't violate the First Amendment. Now, a lot of states, remember, have their own version of the First Amendment in their constitutions. Okay? So it's not as distinctive as it seems. But in some cases, it has made a difference. Okay? Now, over time, the court has applied this principle to almost all of the Bill of Rights. Almost all of it is applicable to the states now. Okay? The exceptions are the Third Amendment, which talks about quartering soldiers, which we don't worry about right now because the government didn't do it. The Seventh Amendment right to a jury in civil cases. The Fifth Amendment grand jury requirement. I explained grand jury to the other classes, but I think if you want to know what a grand jury is, they basically investigate crimes and determine whether to make a charge. They're different than the jury that decides whether or not to convict somebody. A grand jury is about twice as big, they're like about a couple dozen people. There's one of them that has been investigating the Russia charges. This morning, one of them published an indictment. The jury decided to charge Julian Assange, who's the head of WikiLeaks. Okay? So, that's the kind of thing that a grand jury does. But that requirement in the Bill of Rights does not apply to the states. Now, interestingly, last year I taught that another requirement that wasn't applicable to the states was the 8th Amendment's prohibition of excessive bail. Guess what bail is?
Yeah.
Bail is the money that you deposit in order to be allowed to go free pending your trial. It's a terrible system. There's a lot of talk about bail reform because people who have money can pay it and get out, and people who don't have money can't. And it has a really discriminatory effect. All right? But just this year, in this Supreme Court term, the Supreme Court decided that that clause, the requirement that you cannot, the prohibition rather, of excessive bail applies to the states also. Okay? So you might get a question about that on the test because they love to ask you about current events. Yes?
So what would that mean essentially? So since the 14th Amendment applies to...
It means that a state cannot violate this provision in the 8th Amendment. In other words, they can't require excessive bail. Now, what does that mean? There's all sorts of legal books like that you look in and find out what the court has decided in similar cases in the past, and that's how you decide what it means.
Okay.
Okay? It's got a meaning that is developed over time.
Okay. So essentially they're saying for like a petty theft, you can't set bail to be like $1 million.
Correct. Correct. There are lots of different factors that go into setting bail, right? Whether they're a risk to flee, are they a flight risk? Are they a danger to the public, right? How much money do they have?
Yeah.
What effect is it going to have on the people around them? So there are lots of different factors. How much money have you got has been too important. So moving into the discussion specifically of the First and Second Amendments, one of the things that the College Board wants you to understand about these amendments is that they're about individual liberty. So we know that the First Amendment is about speech and religion, right? What's the second about? Bearing arms, okay?
Would you like to see my bare arms? Or should I look at my bare arms?
All right, First Amendment.
Hey, that was funny.
First Amendment is jam-packed with good stuff. It starts with religion, okay? And it says, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Two clauses, two religion clauses. One called the Establishment Clause, one called the Free Exercise Clause. Today, we're going to discuss the Establishment Clause, okay? Now, these clauses, like other provisions in the Bill of Rights, have evolved in their meaning. All right? What a lot of people thought about, establishment basically talks about whether you have a government-sponsored church, or government-sponsored religion. Okay? And in the early days, this was kind of like, well, it would protect you no matter what kind of Christian you were. Okay? But if there had been Muslims running around, who knows? Although there were Jews in the early United States. So it would have applied to them, but some people might have argued not. You know, depending on who you asked. Now, it protects any kind of religion.
Including the Mormons.
Pardon?
Including the Mormons.
Including the Mormons. Except without the polygamy. Without the polygamy. Reynolds versus United States. Okay, so we're going to look at how these two clauses are interpreted, and we're going to talk about different factual situations and how the legal principles apply in different factual situations. Okay? Now, some argue that the Establishment Clause should be interpreted narrowly and that it basically keeps the government from favoring one religion over another. They could spend money on religious schools as long as they did it for everybody. Not very many people really agree with that. Thomas Jefferson, who was not one of the Constitution's framers, sorry about that, it's my earring. Is that better? Shift it around, maybe I'll stop doing that. Okay, so he famously talked about this when he was writing to Baptists in Virginia who were discriminated against. Okay? And he told the Baptists that the intent of the First Amendment was to build a wall of separation between church and state. Very famous words now are used often to describe what the First Amendment Establishment Clause does. Okay, so we're going to look at different kinds of fact situations, and the first type we're going to look at is whether the government can support church-related schools. Okay? Places like Valley Christian or Bellarmine. Okay? What do you think? Should they be able to provide?
No, I don't think so.
You don't think so?
No, they shouldn't.
Now, some people argue that if they provide the aid to everybody, like I mentioned before, what's the problem with that? We could have Buddhist schools, we could have Muslim schools. It's not our fault that they don't have schools. Admittedly, this helps mostly the Christian schools, right?
Yeah.
Okay. Well, the case that decided this, that you used to have to know, but you don't have to know the case name anymore, is called Lemon versus Kurtzman. Okay? And Lemon versus Kurtzman's answer to this question is sometimes. Sometimes the government can provide aid to church-related schools, but sometimes not. Okay? Now, Lemon came up with a test, in my opinion, not a very good test, but a test nonetheless, to try to determine whether a state law providing support to church-related schools is okay. They said you have to look to see whether it has a secular, in other words, non-religious legislative purpose. You have to look to see whether the primary effect advances or inhibits religion. It needs to be neutral. And you have to look to see if it fosters an excessive government entanglement with religion. In other words, do you have to have a lot of government people worrying about this? And is there a lot of mess? Kind of. Okay? And those aren't real clear. They have been interpreted over time a little bit. In Lemon, the court used the test to strike down a law that provided state funding for teacher salaries at religious schools. So the state was giving money to the religious schools to pay for the teacher salaries. So what kinds of things are okay? Buildings. But that probably depends upon the building. If it were a church building, it would not be okay. If it's a school building, it's okay. Textbooks, computers, other instructional equipment, lunches, transportation to and from school, but not field trips, which we'll say in a minute. They can help administer standardized testing. Okay. What can't they do? Like I said, teacher salaries are out, and you can't provide field trip transportation. Now, what's the difference between these things? Why are these okay and these not? Yes?
Because I think paying teacher salary can be interpreted as paying them to teach you religion.
Yeah, that's definitely a big part of it, okay? We're never going to know whether the teachers whose salaries we're paying for are teaching religion or not. How hard would it be for us to monitor that? Okay, so that would make the government entanglement really bad, okay? How hard would it be to figure out where every field trip is going? That would be a pain, okay? It wouldn't be that many, but it would be a pain, yeah.
So it says that it's allowed for textbooks, but that doesn't apply to textbooks of religion, right?
Correct. It's math and science textbooks, things like that, okay? These, we can tell whether the building is going to be used for religion. If it's a school building, presumably we can figure out what it's used for. Same with these things. We can actually check them. They don't require continued monitoring, for example. Okay? And that's probably a big part of why they're different. Okay? It's easier to make sure that the first group isn't being used to teach religion than it is with the second group. Okay, now, just to let you know, this has loosened up more recently. The church allowed public school systems to send special types of teachers into religious schools, probably the special ed teachers, things like that. So that's not so bad. I can live with that. But they also said that a program that gave them money, vouchers, to go to private schools, private religious schools, was okay for some students. That I have a problem with. They allowed them to use government money, which is what vouchers are, okay, to use to go to private religious schools, to pay for their tuition. And I don't know what the circumstances were. There must have been some freaky circumstances for them to allow that. But this is a big political issue, vouchers. A lot of Republicans like vouchers because they are the ones that tend to have money. They're the ones that tend to send their kids to private school, and they would like not to have to pay for their child's private education without either getting a tax deduction or a voucher from the government or whatever. It's not enough that they have the money to send a kid to private school. They want the government to help. I'm exaggerating a little bit, probably. Okay, now, other religious activities in public schools. Okay? If a public school allows student or other kinds of groups to use the facilities, okay, to publish magazines, to have clubs, then you gotta let everybody do it, including religious groups. You don't get to keep them from being a club just because they're religious. Okay? You're not sponsoring them. You're just allowing them to have meetings. We used to have a Christian club here.
Oh, so that's like, could we like establish like
Yeah,
our own
we could.
religious
We used to
club?
have one.
Can we form cults?
If you want to.
She literally said we can just form a cult.
Well, if the school decides that it's somehow a danger to the safety of the students, then you're going to have a problem. So if your cult practices animal sacrifice, you might have a problem. Or even human sacrifice. Then maybe you're going to have a problem if you say that your cult requires you to sleep in class. There is a conflict. There's a conflict between that.
No, we asked if it's possible to start a cult
Yeah.
under this, and she said technically yes, as long as it doesn't endanger students.
If it doesn't create dangerous situations. Oh, the sleeping part. No, it's not dangerous, but it does inhibit the learning. So schools have a lot of leeway in terms of how they interpret laws and apply laws for two reasons. Number one, we're supposed to keep you safe. Okay, so we can do things that we wouldn't ordinarily be able to do because we want to keep you safe. And second, we have a learning and educational function, and anything that keeps us from doing that, we can also stop. Okay? So for example, if the Tinkers wanted to, instead of just wearing armbands, they wanted to have a big bonfire in the middle of the school hall, that's not going to go. It doesn't matter why they want to have it, it's not going to be okay. All right? Oh, this is good. Public school may not permit religious instructors to come into public schools during the school day to provide religious education. You know who did this? The Mormons. Mormons did this. They would have public schools, they would bring in a religious education teacher, and they would have a period in the day for religious education like you do at private schools. The court said, can't do that. You know what they did instead? They built a building next door to the school where they installed their religious education teachers. And then the court said it was okay for them to release their students during the day to go to this building to have their religious education classes, and then they could come back when they were done. That's okay. And my sister told me, who lives in Salt Lake, told me that's the Mormons who do this.
Mormons are scary.
Yeah, well, we're not gonna, do we have any lines?
Same. But they're like not
I
a
can't do that.
they're not a practicing Mormon, but they're like, yeah, my family is Mormon.
Really? They're called Jack Mormons. Have you ever heard that? Non-practicing Mormons. Or actually, maybe those are the Mormons that smoke and drink and things like that.
Yeah.
Okay, another thing, a public university can, if it wants to, it can refuse to give a scholarship to a student who's pursuing a devotional theology degree. In other words, a religious degree. Not a degree about religion, but a degree in teaching people to be religious. Okay, and it said, you don't have to pay for giving them a scholarship. If that's what they're doing, you don't have to do that. Okay, now, next hot topic, school prayer.
Yes, I remember that one. This is one of the ones we need to know.
Can you pray in schools?
No,
Absolutely you can pray in schools. Nobody is stopping you from praying in a school.
you can't be forced to pray.
Correct. So you will hear from the religious right that school prayer, we can't have school prayer. That's just, if you'll pardon the anti-religious slur, bullshit. Okay? I shouldn't have done that.
You can censor it.
It's a term of art.
Yes, free expression,
Yeah.
freedom of speech.
Anyway, you can't sponsor school prayer if you're a school. Okay? The case for this, one of the ones that you have to know, is Engel versus Vitale. Engel versus Vitale.
Didn't they make a movie about this?
I don't know.
Yeah, there's a movie about this.
So, it can't be school-sponsored prayer. We can't say a prayer over the announcement, in the announcements in the morning. We did that in my school. Yeah. You can't have prayers at graduation. We did that in my school. You can't have prayers before football games. I'm sure they're still doing that at my school. And you can't have moments of silence where your real intention is to have prayer. Because they tried that. They said, no school prayer. They said, oh, we'll have a moment of silence. But they made you stand up and participate in it. Okay? And they also decided that it was humiliating not to be participating. And that was hard for like a second grader.
Oh yes, there is a movie about it. It's called The Most Hated Woman in America. It's about the woman who went to the Supreme Court for it.
Oh. Her name? Does it say?
No.
Okay. I know her name. Also, you can't make them recite passages from the Bible. Now, people had a fit. They banned school prayer from the school. They banned prayer from the school. It's terrible. God is dead. You know, all sorts of things, okay? Schools are schools. Public schools are public schools. Churches are churches. Nobody's saying you don't have to live according to your faith in a public school. But the school cannot make you do that. Of course, many have simply ignored the law. Okay? Now, next topic, evolution. Because as you know from studying the Scopes trial, yes, as you know from studying the Scopes trial, many states banned the teaching of evolution in the early part of the 20th century. And in the Scopes trial, because it was the law and because of the states the case was in, poor teacher lost. Okay? But later on, courts said you cannot ban schools from teaching evolution. So, you know what they did next? They said, well, we've got a science too. Ours is called creation science.
Oh, I heard
Creation
about
is
that.
Okay? And creation science says the same thing that the first chapter of the Bible says. Okay? The earth was created in 6 days and it's 6,000 years old, etc. Okay? Now, if you believe this, that's perfectly great, but I don't think you can make other people believe it. Okay. And the court said, no, you can't do that. It's not science. And they said, well, it's just a theory. And the response was, evolution is just a theory, but there is evidence that supports the theory of evolution. There's not really any evidence that supports the particular features of the creation science. So after they got that tossed, okay, then they came up with a new theory. They called it intelligent design. Okay? And it said that the world is such an amazing place, creation is so amazing that there must be a creator. It couldn't have just happened by chance. Okay? Once again, do you have any evidence for this? I mean, it's perfectly fine to talk about in church, okay? But is your religious belief what should be imposed on everybody? Especially when there's no data really that can back it up. It's a matter of faith, not a matter of science. Oh, did you see this? That's really good. Okay, we are almost done. The last thing that has drawn quite a bit of court attention is public displays of religious symbols. Okay? Roy Moore, the senator from Alabama that was running and that got in trouble for the child sexual misconduct, okay? He got kicked off of the Alabama Supreme Court because he put one of these in the court and made other courts have them too. And the federal court said, you can't do that. Okay, because the First Amendment applies to states, all right? Now, so you can't have a public display of a religious symbol if the intent is to promote the religion, right? But if it's Christmas time and you've got a nativity scene and you've got something for Hanukkah and you've got something for Kwanzaa, in other words, you're not excluding anybody, you're okay, you can do that, okay? But you can't favor anybody. All right.